SJC-10581, Commonwealth v. David Perez.
Ms. Campbell, good morning.
Good morning. Good morning, and may it please the Court, Kaylin Campbell on behalf of the Commonwealth. With me today is John Pappas, who is the trial counsel in this case. We ask you today to reverse the allowance of the defendant's motion for new trial because the judge abused her discretion in two separate ways. The first was by making a critical, erroneous factual finding, and the second was employing an incorrect legal standard in analyzing both prongs of Safarian. If there's no objection from the bench, I'll start with the first, which was the erroneous factual finding. And I think it's important, this is not just a subsidiary finding that's not important to the conclusion in this case. This is a critical finding which the judge used to then support her legal conclusion. And specifically, she found that Attorney James had no knowledge of Andale Sanchez's prior testimony that the defendant was inside the bar with Sanchez at the time of the shooting.
Could you answer a preliminary question?
Sure.
Was it she, Judge Sanders, who had denied the motion for continuance?
Yes. She was and it was multiple motions for continuance as well.
Are you done with answering?
I am.
Okay. What difference does it make if the if Ms. James doesn't have, there's a finding she didn't have knowledge, but the facts, as you're going to tell us, bear out that right as the trial starts, she's handed a bunch of transcripts.
Correct.
Which have the witness's testimony in them.
Correct.
On ineffective assistance of counsel, if she has a stack of transcripts, but then she testifies in the post-conviction hearing that she never reviewed it, and she was kind of overwhelmed by the trial and never bothers to read the witness's testimony, don't we get to the same point of ineffective assistance of counsel anyway?
And to answer your question, no, not here, because that's not what was borne out by Attorney James's testimony. She doesn't testify that she never read the transcripts, specifically on motion transcript volume 2, page 22. She says that she reads it, she had it, and page 22 onto 23, 51 through 52, she testifies that she did in fact read Mr. Sanchez's trial, the trial testimony as soon as she got it. I think it's also important, and the record bears this out.
She doesn't weigh whether to use it or not. There's no strategic choice. She kind of just says, and then she's asked pointedly, well, why not? She goes, I don't know.
And she also doesn't remember. And and this is the frustration that comes often in these cases where post-conviction motions are litigated so far removed from when these decisions were actually made. And I applaud the court for making efforts to make that less in time, but I don't think that the Commonwealth should be faulted for the lack of Attorney James's memory when she's forced to testify about this, I believe, 12 to 13 years after she made that decision.
But Judge Sanders has to make a determination as to whether or not she was effective. She has a hearing, as she should. It makes findings as the trial judge that her failure to review, to research, to investigate the witness's testimony was inexplicable, right? Aren't you kind of stuck with that finding?
No, and I'm not stuck with that finding for two reasons. The first is that at the time that Attorney James was called upon to make the decision to call or not call this witness, she testified, and she's not discredited, and it's not refuted in the record, that she had read this trial testimony from the first trial. So this is not simply a case in which there's no information. The second reason is, my brother makes the point that this is a failure to investigate case. I refer to it as a failure to call a witness case. I'm not sure what further investigation would have revealed in this case. This is not like the cases in which there's a failure to investigate, let's say, a criminal responsibility defense, and had you investigated, you would have gotten an expert who would have testified to X, Y, and Z. This is a case in which Attorney James was told about this witness prior to trial by the defendant's mother. She knew enough to put him on her witness list. She had his name read to the jurors, and she had his transcript before the critical time in which she was called upon to decide whether to call him or not. It's unclear what, if any, further investigation would have revealed. And
is it really a failure to prepare case, which combines both of your points?
It could be, but at the point, I'm not sure. At the point that she makes the critical determination, she testifies that she has read this transcript. It's not as if this is a voluminous transcript of hundreds of pages. At the worst, she gets it on a Thursday. That was the first day of trial. That's May 31st. She makes her determination whether or not she rests on June 8th. So she had at least a weekend and multiple days to read this information, to absorb this information. And this is not information that contradicts or changes. It wouldn't have really changed her avenue of defense, which is a misidentification defense.
What about, I think you point out in your brief that manifestly unreasonable is objective.
It is.
So you've got Ms. James, let's just say, overwhelmed. She doesn't think she's going to lose the motions to continue, and she gets all these transcripts at once, and you can almost hear her voice testifying about, I mean, all these inconsistencies, all these volumes, what am I going to do? But say all that's true and credited by Judge Sanders. We still need to look at what Sanchez's testimony would have been with all its limitations.
Correct.
And difficult to reconcile with certain other witnesses for the defense too.
Absolutely.
And say, well, is it manifestly unreasonable with this transcript that we have right now for her not to have called him, even if she was overwhelmed at that very moment she made that decision?
Absolutely, and that's one of the errors I specifically argue that Judge Sanders made, is that she focused the first prong of Safarian solely on a subjective basis and not an objective basis. It's not necessarily the reasons why Attorney James, what she did or did not do, or how she specifically was feeling. It's objectively, would an ordinary fallible attorney have made the determination, knowing what Ms. James did, not to call this witness?
She never did any she never spoke to him, she never interviewed him. Do you think it's negligent for a lawyer to put someone on the witness list who you've never spoken to? Would Mr. Pappas ever do that?
Mr. Pappas would not do that. I'd say that, actually, I want to amend that. We have witnesses often who refuse to speak to us, and
Okay.
sometimes we do put them on
Okay.
our witness list. So
But
I'll amend my answer there.
Someone who the defendant's mother says, I can get for you?
Correct. And that's where the limitation comes with the passage of time. If you read that specific testimony about what she's talking, the conversation with the mother, is that the mother says, he'll offer information, I can get him, I'll call you back. Those things never happened.
But it wasn't done against the backdrop of her having done anything to figure out what was going on. It's like she wasn't doing anything until the trial was coming up.
Correct. And even if, and this is the...
So that's not very good, is it?
Is it? No. I would agree that it's not, but the question is not whether it's good or bad or whether it's a
But how do you
perfect
evaluate
attorney.
then what she was doing? So the first time she really kind of confronts all this information is shortly before trial. Whether or not
Shortly
she
before
should-
trial,
whether
correct.
She should have or should not have is not the point, but I just want to make sure that we're on the same page as far as factually. She didn't do anything before the trial.
Well, I disagree that she didn't do anything before trial at all. The question is
When
looking
did
at...
she start doing it?
I'm not sure what the it is that you're referring to, not to be
Trial
obtuse, but...
preparation.
Sure, she prepared for...
That's the witnesses.
Yes, and we're talking specifically about Mr. Sanchez. And the question is what she did with Mr. Sanchez. That's not to say that she didn't prepare for this trial in any way. She testified that she did. But even if this court, we're focusing on the first prong of Safarian, but here's where the second error in this case occurs, is when we go to the second prong of Safarian.
But before you leave that, and I don't know if you feel any much better on the second prong, and as you know, Safarian doesn't apply to us, but on your first premise that Judge Sanders made a factual finding that was erroneous, the first trial attorney testifies actually inconsistently. At one point, she said she didn't have time to review and analyze the transcripts, and she pointed to other things that she didn't do. Then a second time, she says, well, I might have reviewed the transcripts. I don't have no recollection of doing so. So can't Judge Sanders look at conflicting testimony and decide which portion she credits?
She could, but I believe the page, what page specifically are you referring to?
I don't have the page. I
Okay.
just have it in a memorandum.
Because there's two specific, the problem with Ms. James's testimony is she's talking about two different transcripts. Below it was alleged that she was ineffective for failing to call both Mr. Sanchez and someone named Jonathan Soto. She specifically says that she doesn't remember the specifics of Mr. Soto's testimony ever.
But I guess the bottom line is that Ms. James does testify that Mrs. Sanchez just slipped through the cracks, right? Is that an effective use of an alibi witness who just slips through the cracks?
Sure, but even if it's not, so even if we
Oh,
were to...
we'll get to your prejudice argument now.
Okay.
All right.
Yeah.
All right, you've got a bunch of you've got some identification witnesses, two witnesses pick them out of a photo array, right?
Correct, as the shooter.
As the shooter.
I'm sorry, as the shooter or the person who had the gun?
Yeah,
Person who had the gun, I
someone who had the
apologize.
gun. And
Correct.
four of them don't, right?
Correct.
And that's a strong case?
Four of them don't. They do give descriptions that are consistent with what the defendant looked like. I would say that strengthening this case is that people who knew the defendant well, Andy Matos and Lisa Lee, do put him outside at the time of the shooting. Critically, nobody puts him inside at the time of the shooting.
I guess that's what makes it so compelling, that Sanchez puts him inside.
I don't think but, and here's where I think Judge Sanders really did err, and what I think the sort of the critical focus and the critical error really is that Judge Sanders reached that conclusion because she said she couldn't consider credibility at all. And that's simply not the case in the...
Where did she say that?
She says that specifically, I have the opinion right here.
I recall that, but maybe you're right.
She cites Hampton. It's on page 6. And she says, if you look at the transcript in the argument, during the argument in the motion, she said she couldn't consider credibility. She then talks about how it was for the jury to decide credibility of this witness, but I would say that the proper inquiry is looking at this evidence and asking if there were problems with its credibility.
What do we make of the fact that trial number 1 is with Sanchez, mistrial? Trial number 2, without Sanchez, guilty, first-degree murder.
I don't think you can make any, I don't think you can draw anything from that, because who knows why first trial was a mistrial. There could be one lone holdout who was never going to find this person guilty no matter what the evidence was. And that comes up during the argument on the motion hearing too. And I simply don't believe that you can draw any sort of inference about that. But I also think that this is a case in which typically in the cases that I was able to find in a failure to call a witness type situation, there isn't an analysis as to prejudice because it typically doesn't get past that first prong. And I think it's an interesting situation in which if this was...
But aren't most of the failure to call witnesses cases strategic decisions?
Yes.
Which this isn't.
I'm not sure that you can say that it isn't. At the point that she decides not to call this witness, she's had the transcript then for 9 days. It's not a long transcript. It doesn't contradict or harm her defense in any way. Is it an ideal way to practice law? No. But is the defendant entitled to an ideal lawyer? Also no.
But is he entitled to a lawyer who says about a key witness that the witness just fell through the cracks?
Again, and that's where I think it's important to look at this witness's actual testimony and ask whether it would be a key witness.
But now you're sort of circular, because if we look at the testimony in the first trial, it would exculpate the defendant, correct?
It would, but just because evidence is exculpatory doesn't mean that you would be ineffective for failing to present it at trial.
Yeah, but usually on the prejudice prong, we look to see whether evidence is cumulative, right?
You look to see whether the evidence is cumulative. There's really not, I couldn't find a case that was directly on all fours with this type of case.
For a good reason.
No, and I disagree with that respectfully. I think you view it as you would any other evidence that wasn't presented to a jury and ask whether there are such problems with it, such problems with its credibility, how it compares to the other evidence of that point on trial. I think critically here, this witness, though he did offer this one exculpatory piece for the defendant, even when you look at his direct examination testimony, his answers are largely, I don't remember. He also would have significantly weakened the defendant's argument rebutting the Commonwealth's case about consciousness of guilt, and that he did provide direct and express testimony that the defendant was in fact living in Boston at the time of the murder and that he was not living in Puerto Rico. The testimony of the witnesses at trial on that point wasn't quite as strong or direct that the defendant was in fact living in Boston at that time. I see I have 1 second left. I'm happy to answer any questions.
I've got just two questions. How long was the first trial?
How, off the top, I think they were about the same length, which is about, I think there were about 5 to 7 days of trial testimony.
Was it full days or half days?
Full days.
Full days. And did the attorney before the second trial not get any part of the transcript until the first day of trial?
She did. Her testimony was that the transcripts were coming in piecemeal. And that the certification on this specific transcript does say May 1st, which was the first day of trial.
And do we know what the certifications were for the others?
It is in the record. Off the top of my head, I don't know.
So we will be able to examine the extent to which she was overwhelmed with transcripts.
Sure. On the point of transcripts, though, many of these witnesses also testified at the grand jury and gave statements to the police, so it's not as if what their testimony would be was unknown to Ms. James before trial.
Okay, but we're speaking about, in a case like this, small things matter. So a careful review of what the person had earlier said in terms of what they saw and when they saw it and how certain they were would be relevant to a competent defense attorney.
No, and I don't want to downplay that, but I just want to make sure that I'm not leaving the court with the impression that she otherwise would have had no idea what the statements.
But Sanchez was never in a police report and never in a grand jury.
No, he testified that his involvement to the case came shortly before the first trial because a defense investigator called him.
But it wasn't like she would have had a police report or grand jury minutes to know what Sanchez had to say.
No, but it was her own witness
Right.
and her client's friend and the defendant's own process by which he got involved in this case.
And with regard to the standard she applied, I think the ultimate standard she applied on page 6 is quoting from, oops, I just lost it, quoting from Hampton, which is quoting the Alvarez decision. The proper analysis was not what the judge believed, but whether the testimony may have had a significant impact on the jury's assessment of the evidence. Is it your view that that's a wrong standard?
That's not a wrong standard, but what she could consider in trying to determine what the potential impact on the jury, she relied on Hampton, which was incorrect. Hampton is a case that involves self-defense, so necessarily you would, first of all, it was dealing with the first prong of the ineffectiveness question, but aside from that, it was a self-defense type case, so you would necessarily credit what the evidence that witness had to say in the light most favorable to the defendant.
Okay, thank you.
Thank you.
Mr. Shaw.
Chief Justice Ganson, may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Mr. Diaz Perez. The judge's decision in this case is fully supported by the evidence of what happened.
Why did this case take so long?
Good question. Mr. Diaz Perez went through 5 attorneys.
5 post-conviction attorneys.
Yeah, and when I got the case, I contacted Ms. Campbell. She was gracious and worked with me to get the discovery that was missing from the file. And there were some transcripts issues. Apparently, the prior counsel thought there were transcripts issues. There was a transcript missing. I was able to get that in fairly short order. And it's troubling.
It is, right.
So the evidence establishes that trial counsel in this case was assuming and expecting that because there was a court order for transcripts that had not been fulfilled, that she would be able to get a continuance. She didn't pursue getting a continuance until shortly before trial, and when that was denied, she was overwhelmed and she was scrambling to prepare. And she testified to that. She was overwhelmed. She was under tremendous pressure. She referred to things that she had to do things like review the grand jury minutes, review what the prosecution had provided. And she did not, I think when you look at the certifications on the transcripts, you're going to see that most of them are the first day of trial. So she did not have a lot of information. She didn't have the benefit that the prosecution had. She didn't know who had been called previously, how they had been questioned, what they had testified to. And at the evidentiary hearing, she admitted, as painful as it was, and you know, this was not easy for Ms. James. She was pained by what happened, and it was obvious that clothed in this assumption that getting the transcripts was the first essential step to the case moving forward, she did not attend to the case. So she was put on notice that Sanchez was a witness. She did not follow up with prior trial counsel. She did not follow up with Ms. Perez. She did not ask her investigator to contact Sanchez. She didn't do anything.
She didn't ask for the continuance right at the eve of trial and really explain it well. I imagine she would have gotten the continuance if right before trial she explained the situation.
I mean, her motions are, you know, I don't know that I can judge on that. You know, she was late in getting the ball rolling, that's for sure. But the end result is that she did, in fact, go into a first-degree murder trial, not knowing what he was going to testify to.
5 months, was it? She had the case for 5 months? That might be.
Your Honor, I don't remember specifically. I think
Did she do any investigation during that time period from trial number 1 to trial number 2?
I think that she did little to none, quite frankly. And based upon her testimony that she needed to do things like review grand jury transcripts, figure out what the witnesses were saying, I think it's pretty clear.
Was there, maybe you remember the docket better than me, but was there a request for investigative funds?
I believe there was, but I don't know.
If an investigator was hired and did anything?
I don't know, Your Honor. I haven't seen anything, and I think that certainly nothing happened with respect to Mr. Sanchez. Now, on the issue of strategic judgment, she wasn't exercising strategic judgment when she was consumed with the need to engage basic preparation in a case that she really considered to be complex.
So what do you say about Ms. Campbell's argument? Let's just assume that this is just not even close to what needs to be done as it relates to Mr. Sanchez, and it's inexcusable. I think the Commonwealth's position is you still have to look at the testimony, which is inconsistent with other witnesses on matters large and small. You got to look at the consciousness of guilt testimony, and that objectively look at whether or not not calling Mr. Sanchez would be objectively, manifestly unreasonable. Number one, do you agree with that's the law? And if number two, you do, why wasn't it?
Your Honor, I don't agree that that's the proper approach, and I would answer the question in two ways. To begin with, I think it's very important initially to recognize that the absence of any investigation prior to trial translated directly into an inability to use the information, and that's very important to understand. She gets a transcript. She said she couldn't even review it until like the middle of trial. She's got this information. She says, I didn't know where he was. I hadn't searched for him. She couldn't call him. She couldn't use the transcript. She couldn't establish that he was unavailable. To establish that he's unavailable, she has to have made a good faith effort to find him, and she has to have tried to obtain his presence through process or other reasonable means. She couldn't use the prior testimony. She said the ship had sailed at that point. She had lost the opportunity to do this. There was no strategic decision exercised at that point in time.
She didn't go through that analysis, though.
I'm sorry?
She didn't go through that analysis of where is he, can I use him? She said it slipped through the cracks.
Well, that's right. He did. But, I mean, even if you assume, and she was very equivocal about whether she even meaningfully reviewed the testimony, but if you assume that she did, I mean, it didn't matter. So that's why the judge is focusing on the lack of knowledge. There is lack of knowledge and no strategic decision. Judge Sanders is not looking at what happened in the middle of the trial as if that was an investigation. The fact that a transcript showed up doesn't mean that it became an investigation and that strategic judgment was exercised. Now, with respect to your question, Justice Lowy, on the standard, let's look at what the Commonwealth is really asking the court to do. The Commonwealth is saying, ignore the absence of an investigation and the absence of strategic judgment as found by the judge. Imagine that a transcript becoming available in the middle of trial is an investigation. Then imagine that counsel made a strategic judgment, and then, based on that, apply the manifestly unreasonable standard. Now, that's the wrong standard. We apply the manifestly unreasonable standard when there's been a tactical judgment. If that was the proper approach, then in every single ineffective assistance case, the manifestly unreasonable standard would apply, and all we would have to do is come up to this court and consult your imagination and your judgment and have you determine, well, if this scenario, which really didn't occur, had occurred and counsel made a strategic judgment, would it have been manifestly unreasonable? We don't do that, right? So there was no strategic judgment here. That's the judgment that the judge below made.
Because the defendant's entitled to a judgment from counsel.
Oh, he is. And then the next question is it prejudicial? Now, the differences that we have relative to that standard is that they want you to look at a transcript, and by the way, I think that Sanchez was actually a compelling witness. You know, I think when you...
But either way, we have a finding by the trial judge.
That's correct.
On prejudice that we should defer to.
You do have a finding by the trial judge. But for example, you have a finding by the trial judge. Hampton is right on force with this case. And at one point it says, quote, "It is enough for the witness's testimony to have played an important role." In other words, what Judge Sanders is supposed to do is, based on her knowledge as the trial judge, presiding over the case, look at what the evidence was and the state of the evidence. She's looked at the fact of Sanchez's testimony, and she's supposed to determine, would it have played an important role? Could it have raised a reasonable doubt? She's not supposed to act like another jury and go in with all of these nuanced judgments about what she would believe. The cases say precisely that's not what you're supposed to do. This case, in the Roberio case, says, quote, "The judge's inquiry should have ended when he concluded that the defendant was deprived of a substantial defense." Then goes on to address credibility and says, quote, "The fact that the witness was weakened by cross-examination is not relevant in deciding the new trial question." So, in other words, there isn't supposed to be this very nuanced judgment and acting like another jury.
But we don't view the evidence in the light most favorable to the defendant when we evaluate a motion for new trial. We evaluate in view of the totality of the evidence and the weight of the evidence,
Yes.
whether it may have made an important difference.
I think that there is, I think that's true. I'm not saying that Judge Sanders did not say that she could not assess credibility at all. She's making more of a generalized determination. She's not acting like another jury to determine what she believes was credible or not credible. The cases are very clear not to do that. But yes, you look at the evidence, you look at the testimony. Interestingly, this court in Roberio did make the statement, quote, "We evaluate the defendant's evidence in a light most favorable to him to determine whether it might have influenced the jury's conclusion." That was in the context of a lack of criminal responsibility, a failure to raise a lack of criminal responsibility defense. So there's that. But I don't even think that is necessary in this case.
What do we do with the statement of Judge Sanders, which said that she did, that Ms. James did not read the transcript, or was not?
Well,
I'm trying to find the language of it, but I think she says, quote, "with no knowledge about his prior testimony," is the quote.
I believe that Judge Sanders I believe that her emphasis is the fact that this attorney went into a first-degree murder case having known nothing, having done no investigation, that fact translated directly into an inability to use the information. Her findings are focused on this failure of trial counsel going into this trial. She's silent about, a specific determination about whether at the middle of the trial, Ms. James testified that, it would have been several days before she could have even thought about what defense she was going to present. That's how behind the eight ball she was on this. But, I don't think Judge Sanders is saying she did review it or she didn't review it. She views it, there was nothing, it wasn't of use to her at that point. That's what the judge's emphasis is. If you look at her findings, the findings she makes, which are at pages 3 and 4 of her decision, are addressing this time period before trial and the complete failure to investigate and going into the trial knowing absolutely nothing about this witness. Now, I'd like to address the facts of the case for a couple of minutes, and the Commonwealth's characterization of the evidence, which, as you might imagine, I respectfully disagree with. And I liken this to sort of looking through a camera lens and defocusing just enough that the detail disappears and it merges into a cohesive picture. In other words, their presentation of the strength of this, when you read their brief, depends upon the omission of detail. This was not an overwhelming case. The Commonwealth agreed to that in closing argument at volume 2, pages 89 of the evidentiary hearing transcript. And what we have here in this case is vague testimony. You have extensive conflict, as you've indicated, 4 to 6 people who viewed the photo array did not identify Mr. Diaz-Perez. You've got 3 people who had direct face-to-face contact with the shooter who did not identify Mr. Diaz-Perez. The 2 people who did identify him, which would be Mr. Kelvin Nova and Franklin Ortiz, were friends. They didn't make that identification until 4 days after this incident occurred. And when you look at their testimony that and the descriptions they provided immediately after the incident, it was conflicting and it was vague.
I'm sorry, you said they were friends. They were friends of each other, not friends of the defendant.
That's correct. That's correct. Now, there are some other issues that I'll just address briefly, specific assertions. I can't address them all in the time I have left that I believe are inaccurate. For example, the Commonwealth has indicated that Analdi Sanchez testified that they were there when the grandmother fainted in the hall. Andy Matos, at the first trial, actually corroborates that, okay? Andy Matos then, as the Commonwealth points out, says that when he went outside after the shooting, Mr. Diaz-Perez was out there and he was yelling at these guys. Mr. Sanchez also says that they went outside after the shooting. So that is consistent with Sanchez's testimony. Andy Matos testified that when he did go out at that point in time, Mr. Diaz-Perez did not have a gun in his hand. There was nothing in his hand. There are other instances where I'm not going to have time to address them, but for example, the Commonwealth points out that Sanchez made the statement that he knew where Mr. Diaz-Perez lived. If you look at supplemental record appendix, I believe it's 195, you'll see that the gist of his testimony is that he really did not know. And for example, Andy Matos testified that there was music going on at the time that the incident occurred. That's at Commonwealth's Appendix 109. Again, the Commonwealth is saying that Sanchez said that there was music playing and that was inconsistent with everybody else. It just isn't. So there are a lot of facts here. It is a very complicated case. It's very complicated because you have all of these slivers of perception and observation that are contradictory. And that's one of the reasons why Ms. James felt so overwhelmed. So if there are no other questions.
Thank you.
Thank you.